You can't jettison the people of the state of Jammu and Kashmir and decide that then what's the difference between this and the act of the crown? What's the difference between this and the annexation of Junagadh? Or the annexation of Hyderabad? Then it's an act of paramountcy that I am the union and I will decide. Look at it historically. Let's not forget the law for the moment. Look at it historically. If you look at Europe and the making of the nation states in Europe, how did that happen? It happened because there were large empires, the Austro-Hungarian Empire, Prussian Empire. And those large empires had communities, and within those empires, there were peoples of different languages, of different cultures, of different ethnic lot. So it is the breakup of the empire that led to the rise of the nation state, the Treaty of Utrecht, the 1848 revolutions. Right? In India, the process was the opposite. It's the only exception. The process was just the opposite. There was disparity. There were existing disparities. There were 562 princely states. There were states which were part of the British Crown. They had to be amalgamated. And each of them had certain conditions. But then ultimately they all agreed, okay, for the states that were part of 562, all agreed. But this particular state of Jammu and Kashmir was an exception. And the exception was constitutionally engrafted in Article 370. And the terms of the exception were constitutionally engrafted in 370. You can't jettison the people of the state of Jammu and Kashmir and decide that then what's the difference between this and the act of the crown? What's the difference between this and the annexation of Junagadh? Or the annexation of Hyderabad? Then it's an act of paramountcy that I am the union and I will decide. When you have constitutionally committed yourself that if this is to be done, you have to follow a process which two sovereign authorities have agreed upon and engrafted in Article 370. Otherwise, then it's exercise of paramount power.
In the assimilative exercise carried out, your submission, as I understand, is J&K is an exception because a temporary provision was created for a period of time, and after that it is engrafted permanently into the constitution.
Because you can't revive the Constituent Assembly.
I'm just saying, what is that?
That's what my submission. I appreciate, your lordships have fully understood what I'm trying to say. What is it that you have a state of Jammu and Kashmir with today 14 million people. At that time, they were much less. They have no role to play in their own faith. They have no role to play. If in 1950 it was part of the union, there would be no issue. The aspirations, the desires of the people, whatever it is, Mother. After all, this was something that also had international repercussions at that point in time.
If a elected assembly would want to abrogate 370, even that is not possible.
Not possible. Not possible. That is why they had to do these things in the manner that they did.
But the only way we can reach to that conclusion is by saying that once the period for the work of the Constituent Assembly of the state comes to an end, then what is essentially a temporary provision assumes a permanent character in the Constitution.
But that, yes, not to be that.
But if that hypothesis is not accepted, then the only basis on which you can really, place your petitions here is that by asserting that a pre-constitution compact, which was entered into between an independent state and a state in which it has merged, so to speak, is enforceable, irrespective of what the legislative power of the merging state is.
Because the legislative power, both of the parliament here, cannot override the powers under 356 of the constitution. Because what has been used is 356. There is no such power under 356 that can take
Or
over.
can an independent state, which accepts the sovereignty of another state unconditionally, still say that, well, if the parliament of that state to which we have assumed the sovereignty of is still restrained in terms of the original compact?
It's unconditional, Malaz. It's unconditional. And apart from, forget about that. Can Parliament of India, Malaz, Parliament of India, in the context of its responsibilities and powers under the Constitution of India, do an act beyond 356? Can't. There are very complex issues that your lordships will have to decide. This power is exercised under 356. How is that can be exercised under 356? 356 itself is a temporary power. What are you trying to say to me?
Well, what you are saying, you see, which means even, let us say, a hypothesis that the will of the people is to abrogate it.
Yes.
Which is reflected by an assembly elected.
Yes.
You are saying even that scenario, it cannot be done. Trying to understand the consecutor would be, even then it can't be done.
Well, that would be a political act then, Manoj. I would say that if that situation arises, it would be a political act. That's not been done, but be that as it may. Manoj, kindly look at it from this point of view. 356 itself is a temporary provision. What's the purpose of 366? To restore democracy. Is the intention behind the 356 position, which is a temporary provision, to decimate democracy?
No, Mr. Sibal, let's keep 356 aside for the time being, because we are now interpreting
No, I'm only
370.
saying
We are interpreting clause 3
Yeah.
to
I'm just,
70.
yeah, I appreciate
We
what.
can't bring.
No, I'm only saying these
Look,
are issues
and,
that will
and
arise.
if one looks at it carefully,
Yeah.
subclause B2 says such are the matters in the said list with the concurrence of the government of the state, the president may by order specify. So all other matters which are not included in clause 1 can be now the parliament of the country can legislate with the concurrence
Yes.
of the government of the state.
Correct.
Now, what is meant by the concurrence of the government of the state is specified in clause 2,
Yes.
as long as there is no legislative assembly.
Correct.
In that case, it's the Constituent Assembly which will have the power,
Yes.
and after the state assembly has been constituted, then it will be placed before the state assembly.
Correct.
That's the purport of clause 2.
Absolutely right. So that's also worked itself out.
One.
Yes.
But once the state assembly has been constituted,
Right.
in terms of the constitution of the state, then it is governed by the proviso first and the second proviso to clause 1,
Yes.
which says, provided that no such order which relates to matters specified so and so in consultation with the government of the state,
Yes.
concurrence is not required
That's
because it's
the first
already
time.
included in the
Yes.
order of accession. The second proviso applies when it is not included in the order of
Right,
succession
right.
and says, provided further that no such order which relates to matters referred to in the last provision shall be except with the concurrence of the government.
Correct.
So all that is required is concurrence of the
Right.
government.
Right.
But to say that the proviso to clause 3
Right.
will operate even after
No, it
the
says this
constitution.
article shall cease to operate, not just any laws, that this article shall cease to operate. There's a difference, Malaj. Actually, proviso 1 and proviso 2 have worked themselves out. Because now you have a constitution.
Yes, it's not worked itself out. It will continue to apply as long as there is concurrence of the state government.
That's right. And in between, the constitution in 1957 is framed, Malaj. So that there was no CO after that. except for the ones, there were a couple of COs, but ultimately it's in three, that's different.